Good afternoon. This talk is Hacking Your Non-Compete by Brian Dykstra and Gregory Stone, and this is Islander FG. Thank you.
All right. Like it, my mic's live and everything. Here we go. We got a whole bunch of slides, so we're just going to burn on through this. So basically, we're going to give you a little bit of background. We're going to give you some real-world scenarios taken from actual cases. We'll walk through those. Greg will give you the right way to do it after that. Then we have some quick examples, and at the end of it, we'll give you a checklist of things that you can do to help prevent these types of problems for yourselves or your friends in the future.
So I'm Greg Stone. I'm a partner resident in the Baltimore office of Whiteford, Taylor & Preston, which is a full-service 180 attorney general practice law firm. I serve as co-chair of our technology and intellectual property practice group. So my individual practice is all things intellectual property, IP, patents, trademarks, copyrights, and trade secrets. Also, under that umbrella, we have our cybersecurity and privacy practice group, who represent clients in any and every industry, anybody that touches and handles and stores data, from everything from breach response and risk mitigation to insurance policy review and things like building infrastructure for our clients to help generally limit liability in the event of a breach. I'm a former patent examiner from the U.S. Patent and Trademark Office, been in practice since 1996, and before getting into the IP world was a mechanical engineer working for the Department of the Army.
All right, I'm Brian Dykstra. I'm the CEO of Atlantic Data Forensics. About 80% of our forensics work is in civil and criminal litigation, so mostly with law firms. Helped start Mandiant back in 2003. That was weird. Got about 20 years doing this, worked as a DoD counterintelligence agent for years and a technical surveillance countermeasures agent. Fun stuff. All right, so first real world scenario here. I promise you, I'll tell you how these cases turned out at the end of it, but you can't make these up. These are too good. All right, so this is the worst salesperson in the world. This one actually happened recently. So company A is planning to fire the worst salesperson in the world. They find out that the salesperson finds out he's going to be fired, so he starts looking for a job and he interviews with company B. Company B hires him because they think he's the best salesperson in the world. He's going to be perfect for their company. Company A finds out that he's going to company B, and they're not happy. So company A tries to enforce a non-compete that they downloaded off the internet, because that's how you do real legal work, right? Google knows it all. And a whole bunch of fun starts. All right, so according to the non-compete, the worst salesperson in the world is not allowed to work for anybody that company A considers to be a competitor. So anybody in the cybersecurity space selling any kind of endpoint solution for anything ever, you can't work for them. They also claimed that the worst salesperson in the world had downloaded sensitive client data and provided it to company B as a way to compete directly with them and steal their clients, and so on. Company A, fortunately trying to do the right thing there, didn't provide any computer equipment to the worst salesman in the world. So he's working at this company, working off his personally owned laptop the entire time he's there. So of course there's going to be just a little bit of company data on his computer, things like this. What about company B? All right, company B in this scenario, they hire the best salesperson in the world, right? He's perfect for them. To run as their sales team lead. So he's not working as a salesman, he's working as a sales team lead for them. Provided the employment, they actually prevented him from contacting any of company A's clients. So that was in his original agreement up front. They're like, look, we don't want to get into a thing with company A. You can't contact any of these folks. They also gave him a brand new laptop, and they went so far as to say, look, we don't want you to upload anything. We want no client files from you, no data, no contacts. We're going to do this all clean. You're going to start off as our new sales VP type person. And here's where it starts to go sideways. Company A's attorneys send company B's attorneys a letter stating that they can't employ the worst salesperson in the world, and demand that he return all the data that he stole to them.
And then the fight starts. So we've got first company A's good, bad, and ugly. And actually, they crossed out good because they didn't do anything good. Everything was just a complete mess. First and foremost, as an employer, particularly of tech employees, you need to have policies that govern data storage and handling and use of employees' own equipment and devices. If you take the time to record it, to have written policies, then you're informing your employee of the fact that they've got this obligation to maintain information in confidence. If you're not taking that step of informing them that certain of your information is confidential and that they've got an obligation to keep it as confidential, you're lessening your ability to go out and enforce your proprietary rights in that confidential information. You want to make sure that that information is locked up, you have it documented, and you've got policies to protect it. We talked about the fact that the employee used his own computer. The fact that he's using his own computer does not make the data the employee's, right? It's still the employer's data despite the fact that it resides on the employer's computer. But the rest of the data that's on the computer is still the employee's. So just the fact that he commingled his employer's data with his own data does not make the rest of the data that's on the computer or the computer itself the property of the employer. So think about the mess that creates once you get into litigation, right? During the discovery process, now the other side that's going after and deposing the employee has his computer, is going through a tooth and nail and finding anything and everything that might be personal to that employee. So it's not a good idea for the employer. It's not a good idea for the employee to be using your own equipment, particularly to store company confidential and proprietary information. We also mentioned that he had a non-compete agreement. It's a good idea to have a non-compete agreement with employees that are touching your proprietary and confidential information, but it has to be an enforceable agreement. In order to be enforceable, non-competes have to be reasonable. They have to be reasonable in scope and duration. If they're not, courts are going to throw them out. They're not going to enforce the agreement. As a result, form agreements are really never a good idea. Different employees in different roles, even different employees just at a single corporation, are going to have different circumstances. Somebody that's an hourly employee is going to have different responsibilities from a senior level executive. And so their obligations to keep information confidential are going to vary. You can't have a form document that possibly covers every possible situation. Moreover, as an employee, as a tech employee, you're going to be best served by going in and negotiating the terms of your non-compete. You want clear definition of the metes and bounds of stuff that you have to keep confidential, so that if you do move on to another employer, you know where you're boxed out. So it's always a horrible idea to use form agreements. Enforceability and reasonableness can vary from state to state. So literally, an agreement that is enforceable in, let's say, Maryland, where I'm from, might not be enforceable in California, which is one of the most employee-friendly jurisdictions in the United States. So it's important to realize that agreements can have varying degrees of enforceability depending on where they're entered into. And finally, you need to show, as an employer, you would need to show an actual breach of that agreement. So whether or not somebody breaches a non-compete depends on the specific language that is in the agreement. It's, again, a good reason why you want to negotiate in specific terms, have really clear boundaries as to what is in and what is outside the scope of that agreement, so that, again, you know exactly where you're boxed out. From company B's perspective and the salesperson's perspective, first, confidential, proprietary, and trade secret information of company A is off limits. When you move from one, this should generally go without saying, but it happens all the time. When you move from employer A to employer B, you cannot take with you the company's confidential and proprietary information. If you do, you're likely to get sued, or at least threatened with suit. And imagine if you just started an employee at the new employer and your new employer is getting a cease and desist letter from some nasty law firm saying, you've got to terminate this guy that you just hired. Not a good idea. Sensitive client data is certainly confidential information. Taking sensitive client data without authorization is absolutely misappropriation. It's theft. You're stealing property from the former employer. If it's trade secret information, which is super confidential information, right? If you steal trade secret information, the company B and the salesperson could be sued for an injunction. An injunction is basically a court order that says that you must do something or that you're not allowed to do something. And the scope of that injunction could go so far as to not only prevent use and further disclosure of confidential information, but a court could actually order the new employer to terminate the employee to prevent continued breach of the non-compete agreement. There's also potential liability on company A's part for allowing the employee in the first place to take the information. If they didn't take reasonable measures to lock up that information, and they've let their own client's information out of the bag, they face liability to their own client base. And finally, obtaining an agreement with the salesperson, preventing the solicitation of prior clients, or using company A's data is obviously a good idea. You're taking in new tech employees. You want to have clear policies that dictate you should not be using information that you've brought in from your former employer that is confidential. It's a great idea to do that, but it's not going to be an absolute defense, so you still need to take proper measures to lock up that information.
All right, so I told you I'd tell you how it all ended. Both companies hired really expensive Washington, D.C. law firms. They traded a lot of angry paper back and forth, and then the two CEOs thought a little bit better of it. One of them decided they didn't really care that they lost the worst salesperson in the world. The other one had a lot more money, and they didn't want to fight with him, and so it just kind of fell by the wayside. The forensics of it is the files that he claimed they'd taken were actually 3 years old. Log analysis and metadata on the files showed they were 3 years old, not related, weren't recently downloaded, didn't have anything to do with anything. Just leftovers. All right, this story is too hard to make up. This is the craziest thing ever. So this is how to do absolutely everything wrong when you're planning to leave an employer and start your own competitive company. All right, so we have a company, Blackbriar Equipment. They've been making oil exploration equipment for about the past 30 years. They're kind of a pioneer in their area. They're one of the lead companies in space. Their newly appointed general manager notices that her sales for a quarter are off by about $3 million. So they've been in this space so long that they're just used to winning a certain amount of business every quarter, right? We send out a quote, people give us the contract, we just move on. But now they're off $3 million in a quarter. She thinks it might have something to do with a member of her bid and proposal team that was hired by her predecessor under a cloud, suspicious, from a competing firm. He had a history of some interesting behavior at a previous company. So, GM has us go ahead and look into the computers and email of the entire sales team for the previous 6 months, and we find that not one, but 5 members of her sales team have decided to start their own competing company while working at Blackbriar. And during the day, they worked on the bids and proposals for Blackbriar, and at night, they underbid on their own company that they'd formed called Black Horse. Black Horse Consulting, to be specific. So they were working on one during the day, working for themselves in the evening. They were also redirecting incoming work because they were the sales team. So they were taking clients that thought they were sending business to Blackbriar and going, yeah, this will just go to Black Horse Consulting. It all works, right? And also redirecting some of the invoices and things like this. Good stuff.
So this one's pretty easy. Theft is not a great career development strategy. What they were doing was outright theft. It's no different than if they had stolen equipment or stolen cash from the company. Bid information, that's all confidential proprietary information, if not trade secret information of Blackbriar. So that's all their property. The double timing employees for performing that theft not only face liability for damages, but they could go to jail. They breached their fiduciary duty that they owed to the company. They breached, presumably, employee confidentiality agreements, assuming Blackbriar went to the trouble at the outset of getting confidentiality agreements with their employees. And obviously, a good takeaway there, it would have been good for Blackbriar to have implemented measures to protect against the unauthorized copying and use of confidential information. Building systems that create alerts to personnel if they're copying certain confidential information or if they're just dump copying lots and lots of data. How to do it right? Tell the employer that you're looking to leave. The old rule, honesty is the best policy. Again, don't take confidential and proprietary information because it is the very real property of the employer. It's a good idea to negotiate a well-defined separation agreement that limits the scope of any non-compete. So if you're having a separation, you're talking about a severance package. You know, that's if you haven't already signed a non-compete, that's a time where it's usually going to come up. And it gives you lots of opportunity to negotiate a proper scope. One of the most important things to do there in negotiating that scope is defining what is and is not, in that competitive block, right? So you want to make sure that's clearly defined so that you know you can go to work in this field, go to work in that field. Maybe this employer is off limits for 18 months, but again, it's critical to define that scope. And then finally, just beat them in the marketplace. That's the way to win. Be better at what you're doing than they are.
All right, so telling you how that one ends. One, how many of you think they fired the guy? Anybody? Anybody? Didn't fire him. Did not fire him. $3 million later, didn't fire him. Yeah, we hauled him in and we sweated him just like CSI. Turns out his dad was a luminary in the industry, and we basically threatened to tell his daddy on him what he'd been doing, and he rolled over on everybody else in the group. Gave up all the details, gave up all their chats and instant messaging, you name it, and saved his own butt. And the company kept him on. That's not unusual. We run into these scenarios all the time, and people make what I think are poor business decisions that we can consult. But yeah, that's how it went. All right, giving away your GitHub here. This one's ugly. So company ServiceSoft has an interesting idea for an integrated minibar billing, tracking, ordering, and refill system. Cutting edge, perfect for a place like Vegas, right? There was even supposed to be little robots to help refill the stuff and things like this. Very cool. Problem was, after multiple attempts to make this work, ServiceSoft wasn't getting to a working software solution. It just wasn't all integrating and coming together. So after some searching, they find a developer who has some open source project that's similar to what they want to build, got a lot of good ideas in it, things like that. And so the developer agrees to work for ServiceSoft and assist them to integrate their hardware and software and get this product off the ground and going. Sounds like a good deal, right? Well, after working there for a little bit at ServiceSoft, the developer figures out why there's problems with the company. It's a whole lot bigger than they can't get their software to run right? There's some management issues, things like that. So the developer decides, I'm going to terminate my employment with this place. I got to get out of here. And he goes back to independent software consulting, right? Came from there. I'm just going to go back to doing that. A couple of months after he quits, developer receives a notice from ServiceSoft that his open source project on GitHub is the property of ServiceSoft, and he has to take it down, cease and desist immediately. All your stuff is ours now.
Okay, so the key question here is, given that separation, who owns what from the developer's efforts at that employer? And one of the key issues is that person actually an employee or are they a contractor? And that classification is critical when you're defining ownership of intellectual property. If the developer's an employee, and if that employee is working within the scope of their employment during that development effort, something is likely the property of ServiceSoft. The question is then what? For pre-existing IP that they brought into that developmental effort, it's still going to be the developer's IP unless there was some agreement at the outset between the employer and the employee that said, you're giving all of that to us, you're assigning that IP to us. Unless there's such an agreement, then the developer still owns that background IP. For the IP that's developed at ServiceSoft, not including the part that's carved out as the pre-existing IP, that is owned by ServiceSoft. Again, assuming it's stuff that they developed within the scope of their employment. But it only restricts the developer from using that new and finished product. So absent a non-compete with that employee, the developer is still free to go out and use their pre-existing IP to develop other products, including competing products. Now, if the developer is a contractor, it's a little bit of a different scenario. First, if they're a contractor, then there is a contract typically that spells out the relationship and the duties of the parties. And in that agreement, typically you would see an intellectual property ownership provision that spells out who owns what in that final product that's developed. So the developer really needs to make sure that they're detailing and documenting any pre-existing IP that they have that they're bringing into that effort and carve it out of anything that's being assigned to ServiceSoft. You need to expect that ServiceSoft is going to end is going to own the final product, but just not your pre-existing IP. In both those cases, the developer needs to be careful not to use or integrate ServiceSoft's confidential or trade secret information in any future work, right? So during their development effort, they're in all likelihood finding out some confidential information of ServiceSoft. You need to make sure that that's put aside and carved out and not used in future effort. A good way to do that is keeping a clear trail of your developmental effort. So that, for instance, just maintaining an engineering notebook so that you can actually track your effort and be able to go back through history and look at the stages of development and say, this was clearly background IP that I brought to the table. And finally, there should be a clear separation agreement to avoid later questions or arguments over who owns what in that IP.
All right, so this is one of my favorite ones. 3 guys in an LLC. So, there's lots of that in this space, right? So after working on a SOC team for an online gaming company, 3 developers decide that they can build a better analyst tool platform than the one they're using currently at the game company. Sounds like a great idea. 3 of them quit the game company, work on the projects for 6 months before they unfortunately run out of money without acquiring any new clients for their awesome platform. Personally, I think it's because they're selling to the wrong people, but that's just me. Anyway, so 2 of the guys want to open source the project, and 1 of the guys wants to sell the project basically to any company they can shop it to and get some return on the investment that they put into it. When the other 2 don't agree to his idea, the 3rd guy grabs all the source code documentation, takes off on his own, and he successfully sells it. Yeah. All right, so the purchasing company took the legal position that they purchased the software and documentation from an owner of the company, and any internal problems there might be with that company and things like that didn't have anything to do with them. Not our problem. We purchased it legit from an owner. The 2 developers want the open source project, sued the 3rd developer and the purchasing company, as you would expect. And then both the purchasing company and the newly rich 3rd developer have plenty of money, right? You got 2 other developers out here with no software, no money left, and a couple of groups that have plenty of money to grind them down with lawsuits.
Okay, so first, some best practices that you coulda, shoulda, woulda followed would have been having formation documents. So when you're out and you're starting a new company, whether you're creating a corporation, if it's a corporation, you want to create corporate bylaws, creating a limited liability company, you want an operating agreement. Those formation documents spell out the rights and obligations of the folks that are running the company, that are setting up the company. And so oftentimes in those formation documents, you'll have provisions that detail what happens upon departure of one of the principals or a general just separation or dissolution of the entity. What happens to the IP? You can have buyout provisions spelled out up front in that type of document so that everybody knows when you're coming into that separation scenario, how you calculate what someone gets at that point. It can establish requirements for key decisions that are going to be made, like things like disposition of the intellectual property of the company. So the key takeaway there is it would have been great for them to have those formation documents, but we don't have a time machine, so here's where we end up. They're developing software. Software is, in general, most fundamentally protectable by copyright. There are instances where it can be protected by patent, but from a copyright perspective, we are dealing with rights of co-authors in that work. And so absent a separate agreement among those co-authors of the software, the source code and the documentation are owned by the co-authors that created them. So what that means is that each one of the co-authors has an undivided ownership share in the entire work of the source code. That means because they have an equal and undivided interest, each one can go out without asking permission of the other co-authors, and they can use it, they can sell it, they can grant non-exclusive licenses to other parties to go and use that software. They do, under copyright law, have a duty to account to the other co-authors for profits that they generate from exploiting the work. They can also go out and assign their ownership share or sell their ownership share to someone else. So where does that leave us? You then have these co-authors as co-owners of the software, each one who is now able to go out and freely use the software with years of litigation down the road, suing one another over, oh, you owe me for selling the software over here. No, but you owe me for selling the software over there. Again, issues that could have been resolved by way of having formation documents up front.
All right, how that one actually ended was it did go on for years. The one software developer ended up finally coming to some sort of terms with the other two co-authors, nowhere near what it costs everybody or the time put in, things like that. All right, so this next section I like to call Get Free Legal Advice from Greg. I don't think Greg likes that, but little quick scenarios that we didn't have time to build out full scenarios for. So in this case, we have a situation where my employer says that the work for hire doctrine means that everything I create while employed at the company belongs to them. Everything you do, we've heard this before, right? Everything you create, do, think about while you're here working for me belongs to me.
Right, and that is not the case. We talked about software is protectable by copyright. Work for hire is strictly a copyright doctrine. It only exists under copyright law. So, and basically the meaning of work for hire is any copyrightable work of an employee is created within the scope of that employment is the property of the employer. So does that mean that stuff that you work on moonlighting at home belongs to the employer? I'll give you the typical legal lawyer answer of it depends. Are you an employee and are you working within the scope of your employment when you're developing that work? If so, it's work for hire and it belongs to the employer. If it's something that's your own project that you're working off on site, if you're not getting paid to work on that project at night, then it's probably outside of the scope of your employment. It's outside of the work for hire doctrine. But importantly, it's that work for hire doctrine is just an animal under copyright law, and we'll talk shortly about patent issues and why they're different. Want to just go into this one?
Yeah. So, why don't you head right into it?
Yeah. So, next question. So, if the source code I wrote is copyrighted by my employer, I can't make anything like that. Is that where we stand? No. While the code itself might be copyrighted, the copyright does not protect the functions of the code. Copyrights protect literal expression. And so when we're talking about software, that means it protects the literal code itself. It does not protect what the software does. So there can be a competing product that performs pretty much identical function. But if it does it by way of different code that someone wrote entirely independently, then that's not going to be copyright infringement, and you can have that type of competing product out in the marketplace. As long as that code writer didn't see the original code and say, okay, I see how that works, I'm gonna go and write essentially the same thing, a substantially similar copy of that original work, that's not infringement. And they're totally clear in making a competitive product. But let's say that that piece of software that they've come up with is something that is potentially patentable. There is a new invention that's embodied in the functions that are performed by that software. So if the innovation in that piece of software rises to the level of a potentially patentable invention, the employee owns the invention unless there's a written agreement with the employee that spells out that the employer owns it, or the employee was specifically hired to invent the thing that is patented. So this is a really, really common misunderstanding. Tech employers and tech employees assume that if the employee is developing something that just generally relates to the business of the company and it's something that they can patent, that the employer owns it. And that is not the case. They're thinking in that work for hire sense, but the work for hire doctrine, as I mentioned, is only an animal under copyright law, has no bearing on patent law. And inventions just have a little bit of a higher status than copyrightable works. And so because of that, we treat ownership of them differently. So absent either one of those issues of the employee being hired to invent a specific thing, or there being a written agreement with the employee that says that the employer owns it, then the employee can certainly use the invention, can even file their own patent application and obtain patent protection for that product.
How many even knew that one? I had no idea.
That's right. So the question was, looking at that third point, if either of those conditions is met, right? So it's if there is a written agreement that obligates the employee to assign to the employer, then the invention would be the employer's. And likewise, if the employee was hired to invent the specific thing, then the invention becomes the employer's. Any other scenario, the employee still owns it. You going?
Yeah.
Okay, so my non-compete says I can't work at company X. What do we do there? So we've got this issue of non-competes being overly broad and employers at times taking certain steps to be a little bit overbearing in what they're looking for in those types of agreements. You might have an employee sign an agreement that kind of blindly ties them to unnecessarily binding limitations. You know, you're starting a new job, you're going in, you've got a whole bunch of paperwork to sign, you know, this form, and that form, and one of the forms that's slipped in there is a non-compete. Really want to be careful in that scenario. If you're presented with a non-compete agreement, it really makes sense to have an attorney review it. At a minimum, don't sit there and sign it in the flurry of activity of going through a stack of documents your first week of work. At a minimum, take it home, read it over, be really clear on the limitations that it's setting out. Again, they're supposed to be reasonable in scope and duration. So some agreement that says you as a code writer can't work in the software field for the next 5 years is not going to be enforceable anywhere, because then that type of agreement would deprive the person from their livelihood, right? And courts are not going to enforce an agreement that's going to just totally bar someone from being able to go out and earn a livelihood.
Now, the important part there was the court will enforce it. That means you're not going to get hired at that new employer. That, nobody's going to want to hire you because of this existing non-compete issue that you've got going, and you're going to have to spend money and time that you don't have in a courtroom to eventually win on a really easy matter.
Sweeping descriptions that are designed to minimize competition risk unenforceability by attempting to control non-confidential information. So you might see agreements that say anything and everything that deals with software is my confidential information as the employer. Obviously, that's not the case. Stuff that is generally known information, background information, that's not confidential information. And even if the agreement spells out that you're obligated to keep that as confidential, ultimately that type of provision is not going to be enforceable. But the key issue, Brian just mentioned it. It's all of this is subjective, and the way it gets decided is after you've gone through costly litigation, which is why it's best to deal with these issues up front. My former employer says that everything's a trade secret. So general information that's relevant to an employee's technical field and that's known in the industry cannot be confidential information or a trade secret. Confidential information and trade secret information is information that is confidential, that is kept confidential, and that is secret. In order to avail itself protection under trade secret laws, information has to be, number one, commercially valuable to the person that owns it, and number two, must be the subject of reasonable measures to maintain its secrecy. Literally locking up the information, having restrictions, having things like password access to the information, locking up physical information in safes, and so on. A failure of the employer to specifically identify to the employee what is confidential or proprietary information leaves the question open. So it's really, really a good idea to have that spelled out at the outset. Again, in some written agreement with the employee that says, this is our information, this is the scope of what we consider to be confidential and trade secret information. If you have that at the outset, then that employer-employee relationship can, or I should say, the end of that employee-employer relationship can go so much more smoothly because the employee understands what they can use, what they can't use, if maybe the employer is being a little bit unreasonable in what they're trying to define as information. But in any event, it's best to get that spelled out up front. But if there's a dispute, once again, the only way it's going to get resolved is through costly litigation.
What's interesting about that is generally known information, technical information in the industry. Think about our industry. Network traffic analysis, anomaly detection, from forensics to endpoint monitoring to all those things. Those are generally well-known, well-researched, well-trod over, well-published areas. It's hard to actually legitimately come up with a thing where you go, this is 100% unique to that space and nobody else has ever heard of it or thought of it.
My former employer has a policy I never saw. It's really important for an employer to, that's in a tech industry, to have policies that clearly spell out how they secure information. They might be called upon later on to demonstrate that they took reasonable measures to maintain the secrecy of the information. It's going to be more difficult to do that if they didn't have a policy that spells it out. What's more, if they didn't have a policy to spell it out and they try to sue the employee who's now working for a competitor and they're saying, hey, you took my confidential information. Well, if the employee then is able to establish, look, you never had a policy that dictated or defined what was your confidential information. Now you're coming at me saying all this stuff that I knew in the past is confidential. No, it doesn't work that way. Then finally, an employer should have physical and electronic controls to minimize risk of intentional or unintentional exposure of confidential or trade secret information. Again, it just makes sense to have those policies, to have the infrastructure in place that protects that confidential and proprietary information.
All right.
Got a checklist?
The checklist. So we tried to come up with as many things as we could that you could use for yourself, your friends in the future, share it, all that sort of stuff, to prevent yourself from getting into these ugly sort of situations.
So is information that a former employer is complaining about a trade secret or confidential information, or is it general industry knowledge? As the tech employee, it's good for you to try to keep a log if you can, but just try to be aware as you're working on projects of what's really proprietary to the employer and what's clearly background information, what information is just general knowledge that's used in the field. If your position changes over time with a former employer, it might be the case that your non-compete is no longer relevant to the duties that you had at the time of departure. So if it's spelled out that you can't compete in this certain box of where you were when you started employment, but at the end of the relationship, your job has changed so much that you're no longer within that square, well, if you take a job that's kind of in that same position of where you ended up at the former employer, then the non-compete for your old position just isn't going to be enforceable against the new position.
That was critical with our worst salesman in the world. He worked as a salesperson at company A. He worked as a VP of sales at company B. He didn't actually do sales anymore. He ran an entire sales team. He wasn't directly interacting with clients.
If you're required to sign an agreement when you're departing, are you compensated? So an ideal time for an employer to present an employee with a non-compete is when they're coming in, when they're first hired. Or maybe you go through a process and the company is deciding, look, we want to update all of our forms, all of our employee-related policies, so they're going to present kind of company-wide non-compete agreements. That's fine. But if you're bullied on your way out the door, it's by in-house counsel coming in saying, you need to sign this or else. Well, in order for that agreement to be enforceable, they're going to have to give you something. In order to have a valid contract, you need what we call consideration, some exchange of value. And so if they're trying to force you to sign a non-compete as you're going out the door, but they're not giving you something in exchange, presumably some type of severance, then that agreement's not going to be supported by any value exchange from them to you. It's not going to be enforceable.
How many of you ever knew anybody working in a SOC to get a severance when they left? Or a network engineer to get a severance when they left? Yeah, it's a rare thing, right? It's usually we need you to sign this and be on your way.
In looking at the issue of enforceability, and particularly, I mentioned earlier the risk of being exposed to an injunction, where a former employer is trying to prevent the employment from continuing at the new employer. Key question is there irreparable harm or injury to the former employee moving to a competitor? Is there irreparable harm to that former employer resulting from the employee moving? If they can't show that there's really irreparable harm, they're not going to be able to get that type of injunction, that type of relief. Does the potential harm to the former employee created by the non-compete outweigh the harm to the former employer? Many jurisdictions are looking heavily at reasonableness and fairness when it comes to enforceability of a non-compete agreement. And so if the potential harm to the employee is so much greater than the harm to the employer, then a court is in all likelihood at least going to scale back the scope of the non-compete. Did the former employer bury the restrictive covenants in some otherwise unrelated agreement? For instance, did they revise employee handbooks? And in this 150-page employee manual, at page 75, they insert a one-pager non-compete agreement. And then it's back. They say, here, sign this form saying you agree to our new policies. Well, yes, maybe the timing is good on that non-compete, but they can't slip it in, under the cover that way. They're going to have a lot of trouble trying to enforce that type of document. Did the former employer simply wait too long to take action against the former employee and their new employer? Did the move take place? Employee went to a competitor, is putting out product that's in the exact same competitive space as their former employer. The former employer absolutely knows about it and just waits 2 years to then come, despite having all that knowledge, to come in and enforce.
What is generally too long, Greg? 6 months, a year, 2 years?
It's going to vary depending, on the situation, on a lot of times on just the value of the product. Statute of limitations in a lot of jurisdictions is either 2 years or 3 years, so we're at least dealing in that window. But for something that's some type of huge project, it could be as little as 6 months if it's something that everybody in the world knows these two companies are clear competitors. Let's see, just real quick, because we want to leave a couple minutes for questions. We've got a couple of other items here. Former employer previously only selectively enforced. You got to be uniform in your enforcement. If you're a low-level employee or low salary level, an employer is going to have a tough time enforcing a non-compete. And then again, just the issue of fundamental fairness. Enforcement of restrictive covenants against the employee are simply unfair. Courts are going to look at that basic issue of fairness. The quick do's or don'ts. Try to maintain a log of any public information, resources, open source that you use in your work, so you can establish the public nature of that information if you're challenged after you've moved. You want to be able to defend against the claim that you're misusing confidential proprietary information. If you've got documentation to prove it, you're going to be way better off. Document your own individually developed intellectual property that you did while you were moonlighting, so that you can establish that it was truly an independent effort outside of your regular work efforts. And the big do not.
Don't take the data. Just don't take the data. Don't make me have to come and look through your computer later. I mean, this is what we do. We do hundreds of cases a year. Don't make us find this stuff, on your computer, on your home computer, on your thumb drive. Every stealthy way you come up with, come on, that's what we do. Don't do it. It's better to just walk away clean, like Greg says. Just compete with them straight up.
Good timing. Questions? So let me make sure I heard the question. You're working for the company, they changed their policy and you disagree? That's the employer's prerogative. So your option there is, it depends on your negotiating value as an employee, right? So if you're critical to the mission of the company, then you're going to negotiate those terms. Maybe you've got a carve out, you've got your own non-compete that's not the form for the policies that they changed. And I would certainly recommend that you ask that. And say, no, I can't agree with this. I don't know what the future holds for me. I think because of my particular circumstance, I've got pretty unique opportunities. So let's sit down and talk it through and let me understand what your concerns are so that we can clearly carve out and define what that scope of non-compete is. I think that's probably the best way to handle it.
What if I'm hired at a company that's later sold to another company and a new company says, oh, we have this really strict policy on all this, and you're now an employee of that company?
If they've got the strict policy, that's the policy, right? And you got to educate yourself before you start the employment relationship, because once you're in, you're bound. Again, if it's an overbearing non-compete, there might be enforceability issues, but it's their policy. No, it's the employer's prerogative, right? So they can, as a condition of your continued employment, they are able to say, no, we've changed our policy, and so in order for you to maintain your employment, you need to sign this document. Again, and it depends on your value as an employee. Do you have the ability to negotiate with them and spell out, your carve out from the norm?
You don't have to work there, right? It's not like the market stinks or anything like that. Longest I've been out of work in 20 years is 2 hours or something like that. So, there's always a place to go.
So thanks. I see we're out of time, and we'll be at the there's an after room, right?
There's some wrap-up questions area just outside. If you have more questions for us, Greg and I will go there. We will be there. He will answer all kinds of really tough questions for you.
Yep. Thanks for listening.